We don't want to make this any more painful or less painful. We're excited tonight to be talking to you about Oregon House Bill 4401. Most of you know that this was a major significant change, but to basically an extension and a funding of what needed to happen for tenants through COVID, or for tenants through COVID and landlords. What we've tried to do tonight, Russell, who is the director of our residential department, is going to do most of the presenting tonight. What we're going to try to sort of bring across is that, you know, this is a big bill, 40 pages, but we've sort of narrowed it down to a few action items that are critical so that you can think it through, make logical decisions as you move forward, and try to keep it as simple as possible, because we can always overcomplicate everything, and we tend to do that. As we all know, the world is driven by a pandemic and COVID, and we are all adjusting to it. And governments are trying to keep people in housing, and this is a tool that they're using. Let us go to the next slide, if I may. Thank you. Those of you that don't know, I know most of you do. We've been around. I'm Cliff Hockley, Bluestone Hockley, the president of Bluestone Hockley Real Estate Services. We've been around for, oh my gosh, since before Gene Derringer was born? No. Or something like that. Before both of us were born, probably. No, since 1972. And we are most basically service the Portland Metro and Salem areas, as well as Vancouver. We have over $2 billion in assets that we take care of, which include over 7,000 units of condominium associations, apartments, houses, and 2 million square feet of commercial property. Next slide, please. Russell White, drum roll for Russell White tonight. Russell White's been with us a couple of years now as director of the residential department. Correct? Am I doing that right? Did I say that right? It's been, yeah. And he's been 18 years in the industry. He's worked for GSL, Guardian, Quantum, and Cascade, ever moving upward in his trajectory of responsibility, and started on site and then moved into area and regional management ships. He worked with Multifamily Northwest in updating rental agreements when he served on the committee there. He's been involved in, I was going to say Section 8, but I don't mean Section 8, subsidized housing a lot, as well as managing properties in Oregon, Texas, and Washington. He's done small deals and big deals, and he has quite a bit of experience, and which makes him a wonderful addition to our team, and a great person to be giving this presentation. There's a question here regarding Ordinance 1287, and we will be discussing that. It does not impact HB 4401. That's the answer to the question. But it does impact other things, and Russell will be talking about that tonight, which is the Multnomah County Ordinance. So, next slide, Abby. Without much further ado, we turn it over to Russell White for what will be a wonderful presentation. Questions. Luke will be working with Russell. There will be a couple breaks in between the presentation to ask questions. You can always submit questions on the chat. Don't have to worry about toilets tonight because you're home. And what else can I say? I think, Russell, I think you're on.
All right. Thank you, Cliff. So, you know, kind of what Cliff said, this is the major parts that you should be aware of. I mean, it is a big bill that covers a lot of different things. A lot of things were already talked about in previous eviction moratorium extensions, so we're not going to cover everything, but some of the major differences here in Oregon House Bill 4401. I also want to start out by saying, you know, like the Multnomah County 1287 rescission, there are always more information coming. There's changing stuff. So, you know, if you get a couple months down the road, things may have changed. And so you should consult an attorney before moving forward with anything if you're not 100% sure of what the law is at that moment. And it is confusing because there's a lot of overlapping laws here. So with that out of the way, I wanted to start by addressing the basics of Oregon House Bill 4401. You know, what is it? Well, First, it went into effect on January 1st of this year, and it's essentially an extension of the eviction moratorium, which we've already seen a couple times before. Now, there is a new declaration form that has been introduced, and we'll talk about that. And while a tenant does not have to sign it to get an extension, they will not get the full extension, and you won't be able to apply for rent assistance that HB 4401 has set up. And again, you can see here, they did create a fund. It's $150 million for landlords. So we'll talk about that in a little bit here as well. All right, so what exactly does HB 4401 prevent a landlord from doing? Essentially, you cannot evict a tenant for a balance owed during the moratorium or emergency period through at least March 31st of 2021. And again, we'll kind of go into this in a little bit more detail later on. There is something about declaration forms, and we'll talk about that on the next slide. You cannot evict a tenant for current month's rent in certain counties, and also if they sign the declaration form. Again, a little bit more on that later. Counties have there are a couple of counties that have some different rules. There's a federal moratorium, so there's a lot of little things that we'll discuss here in a bit. You can also not assess a late fee for a tenant's non-payment or report balances to a credit reporting agency or file an action to recover a non-payment balance. So this is like, filing a suit or something like that. And that's new for 4401. Obviously in the previous eviction moratorium extensions, you couldn't, assess late fees, but now you can't even file in court. HB 4401 also changed the 72 and 144 hour notices. These were basically non-payment eviction notices. They are now changed from 72 and 144 to 10 and 13 day notices. It also increases penalties if the law is not properly followed. So what I was talking about before was a declaration form and a notice of tenant rights. This is new for 4401. We had something very similar in one of the other, I think it was 4213, that introduced something and then it kind of went away because there was an extension. So this kind of is the new form, and this is a sample version. It comes from the 4401, text. It's actually a form written into the bill. And we kind of have taken it, putting our own spin on it. I mean, not spin, I should say, but we added verbiage to it. So, our logo, the tenant's address. We also added a little bit here about, hey, what is this? Why we need it? Time is of the essence. Get it back to us as soon as possible. But basically, this is a notice of eviction protection. So this is giving the tenants information about what this is, where they can get translations from, why or how they can be protected. And so the first 2 pages are basically just a notice explaining some of the rules. The last page here is the actual declaration itself. So this is the form that tenants would need to sign in order to get the full protection. And as you can see here, in order to get that protection, they must meet one of the reasons below, which listed here are loss of household income due to COVID, increased medical expenses, loss of work or wages, childcare expenses, or cost for caring for a person with disability, or basically anything else that has reduced their income or increased their expenses. And in one way or another, we've all been affected by COVID. So you can pretty much see this form will apply to almost everybody, and especially those who haven't been able to afford their rent payments. And all they have to do is sign it and return it to us. And they can return it in pretty much any form they want. First class mail, photograph, email, text, anything that they want, they can return it to us in that format. So this is required, these forms are required to be sent out with any kind of termination, balance owing, or eviction notices. That's like an example of a termination notice is the new 10 or 13 day notices. Formally 72 or 144 hour notices. These 2 forms, or essentially this one form for us, is required to be sent out with those notices. Now, we've actually already been sending these forms to people just by themselves. We started sending them out at the beginning of January, and we've actually collected back a little less than half of the forms that we sent out. Now, why do we send these out? without the termination notice or balance owing notices, the main reason is because we can't file for relief from the landlord compensation fund without it. We will need these forms signed by the tenant in order to be able to file for any kind of landlord compensation. And we'll talk a little bit more about that later. Now, without the declaration, so if the tenant does not sign the declaration form, the moratorium balance is due on April 1st of 2021. While that remains true, you know, we here at Bluestone and Hockley are considering all moratorium balances due on June 30th, excluding certain counties. Again, we'll talk a little bit more about the county specific, but some go a couple of days past June 30th. So why are we doing it this way? Well, for one, with as many tenants as we have, it can be tough to keep track of who signed the declaration, what county they're in, who didn't sign it, and try to set up rules for each individual person as opposed to just saying, look, June 30th is when the moratorium expires for everybody. We don't want to make a mistake, incur a penalty or anything like that. But more importantly, even if a tenant doesn't sign it and you file for eviction on April 1st, they have until the first appearance to actually sign that declaration. And if they do, then the case is actually dismissed. And there's going to be advocates, whether it's the OHCS or Portland Housing Bureau, whoever it's going to be, that are going to try and assist these tenants and let them know, hey, all you got to do is sign this declaration, and essentially you have 3 more months of non-payment that you can go through. So it might be just a futile effort to try and, you know, file for eviction in April, unless the goal is that you didn't get them to sign the declaration sooner, and so this is your effort in trying to get them to sign. That could be, but it's also possible by April 1st, all the funding will be gone. We'll see. Now, if the tenant does sign the declaration, you cannot evict them for non-payment of a moratorium or current balance until after June 30th of this year. Tenants do not need to sign the declaration to get this extension if the landlord does not send the notice or rights of the notice of rights or the declaration form to them with the aforementioned forms. So like the 10-day non-payment form that I was talking about earlier, if you don't send these forms with them, they automatically get the extension, even if they don't sign it. It's kind of like a penalty in case the landlord tries to get one over on the tenant, or even if they just forget or don't know the law, this is basically a penalty for them. Once a declaration form is received, we can't dispute it. We have to consider it the truth. We can't require a tenant to submit additional information or require that all tenants in the household sign the declaration. So even if we know this tenant's working, they've got a better job than they had before, if they sign this form, we can't question that. We just have to assume that they're telling the truth. There is something about, you know, committing perjury the tenant might be responsible for, but essentially nobody's really going to be fact checking these. And again, as a landlord, we can't. We also have to accept any kind of translations done by the court through the form. So if we get it in a different language, we have to accept it. And whatever mode of transmission the tenant sends the form to us in. So that could be, you know, like a photograph, a mailing, email, text, however they want to send it to us, we have to accept it in that format. So this is kind of what I kind of created as a chart to explain a bit of the differences between the different counties, cities, or even federally. And it can help a little bit with the confusion, specifically when you want to start an action. That's what this is about. Here's where you can actually start doing this. However, there is a bit of an update here as Multnomah County recently rescinded Ordinance 1287. Ordinance 1287 is basically the ordinance that made these dates August 1st, January 4th of 2022, July 3rd of 2021. Ordinance 1287 is part of that rule. And their rescinding of that ordinance goes into effect February 1st. So as of right now, it is still in effect. In addition to that, basically, I should say, when it goes into effect February 1st, the county would basically fall in line with the state's House Bill 4401. So the county ordinance will go away and they will fall in line with House Bill 4401. And that's just to make things very easy for everybody to understand so there's no confusion because obviously, as you can see from this chart, it is very confusing. Now, the other thing to know is that the city of Portland adopted their own ordinance, which is 190156, and that expands on Multnomah, that basically expands Multnomah's ordinance 1287 to all areas of the city. And they haven't officially rescinded it yet, at least not through their website or anything. Have they officially said, well, we're rescinding 190156. So technically, that's still in effect. And it remains to be seen whether 1287 is going to remain in effect for Portland, or if they will at some point, rescind it, or even if they haven't officially rescinded it because Multnomah County rescinded 1287, does that mean Portland automatically is rescinded? So it is a very kind of fluid situation. Hopefully we'll get more clarification on that later. But as of right now, Portland Ordinance 190156 is in effect, and so that's also why I left these dates up. Now, on January 20th of this year, the CDC director issued a statement saying that they were extending their federal CDC moratorium until March 31st of 2021, which basically says that you can evict a tenant through March 31st of 2021, but that tenant has to sign the CDC declaration form in order for that rule to be in effect. So again, yes, it's very confusing because the CDC declaration form, while very similar to this HB 4401 declaration form, is different. Now, we've been over most of the state restrictions already, so everything listed in the Oregon column, except for the qualifying landlord reasons. These are QLRs that were issued back in SB 608 a year or so ago. Maybe it's been 2 years now. But basically, the qualified landlord reasons for termination, namely the demo, renovations, or have an immediate family member move in, you can still terminate for those. They're currently permitted, except in Portland because of Ordinance 190156. So at this time, anywhere outside of Portland, you can terminate for those reasons. Now, I'm not going to go into all the specifics about those qualifying landlord reasons and how to do it, but just understand you have that ability. You can also still terminate a tenancy if you are selling your home and you have accepted a qualified offer. So those are still some reasons that you can terminate. And originally they were disallowed, at least the demo and renovations, and HB 4401 brought it back so you can still do that. Now, Hillsborough also has their own moratorium, and it extends the termination date, at least for current month's rents and non-payment balances, to February 2nd. So that means you can't file or terminate in Hillsborough until February 3rd. They also did a 6-month extension from that February 3rd date to say, hey, they have until this date to pay any non-payment balance or moratorium balance until this amount, or until this date. It's a 6-month grace period, essentially. And then we have basically the penalties. Like I mentioned, penalties have increased. For violating this law, a landlord may be responsible for 3 times the monthly rent and other damages such as attorney fees. So again, I strongly urge you to consult an attorney if you plan to pursue an eviction. Because as you saw from the chart, there are a lot of differences between counties, and there are a lot of things that are currently changing or are planned to change soon. And so, yes, very important, consult an attorney. And I think we're going to take a few questions now before we move on to the Landlord Compensation Fund.
We have 2 questions that have come in so far, and anyone else can actually chat your questions to Luke Adams. The first one that came in was, when can we send the declaration to City of Portland residents? Can we do that now, or do we have to wait?
You can do that now. As I mentioned before, we've already sent out the declarations. The ordinance also allows you to still send out balance owing letters, and you are required by this HB 4401 to send the declaration and the notice of rights to any tenant that you send a balance owing form to. So yeah, as of right now, you can send that out.
Okay, and then the second question was, what about voicemail left by the tenant? Does that qualify?
We will need the form because when we go to file for the landlord compensation or apply for the landlord compensation fund, we will need a physical copy of them signing or attesting to the declaration. So unfortunately, a voicemail is, as far as I know, not an acceptable form, and it's not written into the law because the law basically says you have to sign this form.
Okay, and one other question. Can you speak to Clackamas County? Is there any information about Clackamas County? You spoke to Washington County and Multnomah.
Yeah, so Clackamas County is basically following HB 4401. They, on their website and on, the Clackamas Housing Authority's website, both of them only mention HB 4401. I have not been aware of any additional restrictions that Clackamas County has as a county as a whole. But you, like I said, you always want to check with an attorney in case something changes.
And one last one, since Bluestone and Hockley is doing property management, does Bluestone and Hockley retain the attorney for eviction?
So what we would normally do, especially in a case like this, and if we're not 100% sure what's going on, or if there are some, like for instance, I mentioned in Portland, they have, their ordinance and, they're going with 1287. If somebody really, one of our clients really wanted to pursue eviction, separate from, the House Bill 4401, or basically following the footprint of 4401, we would probably get an attorney involved. So we would get an attorney. It would most likely be our client's responsibility to pay for that attorney because it would be individual to this one eviction that we would do. So if there's specific questions that I had in regards to, HB 4401 or Ordinance 1287, or whether or not Portland's going to rescind their ordinance, I might talk to an attorney and, I would pay for that separately. But if it's in direct, helping of an eviction for a specific tenant, yeah, we would probably retain an attorney in this particular case, and it would be a client's responsibility to pay for.
And so far, that is all of the questions. So we'll continue on with the presentation. If you have other questions, please send them to Luke Adams. And at the next break, we will then ask those questions for the group.
All right, thank you. Now comes the good part. I have to say today, as I was looking forward to this Oregon Housing Community Services webinar that they were going to put on about the whole application process, for the Landlord Compensation Fund, really looking forward to it. Unfortunately, they were having such technical difficulties that they had to basically cancel or postpone the meeting. Now, this is a real confidence boost because they are the ones responsible for the creation of the online application process to hand out funds for this compensation fund. So not really happy about that. I hope they get their act together and that, these technical difficulties they had just putting on a webinar isn't going to, set up something about the application process, but we'll see. Basically, the state set aside $200 million for assisting landlords and renters. 150 million of that obviously goes towards this landlord compensation fund. Now, in order to receive the funds, the landlord must have a signed declaration from the tenant, a description of the unpaid rent, and they must agree to waive 20% of the balance. So you're only getting 80%. But in a lot of cases, I mean, we have some tenants that haven't paid since April, some since March, and they owe over $10,000. And once the whole, eviction moratorium ends, they'll probably likely owe somewhere in the realm of anywhere between $16,000 to $20,000, and very unlikely that we are going to be able to get that from the tenant. So getting 80% would be very beneficial and more than we could probably hope for otherwise. The landlord must also agree to repay any additional funds received from the tenant so as not to get double paid. And they also can't terminate for non-payment or no cause during the application process. So what I mean by, any additional funds. So let's say, the application gets accepted and you get paid from April to December. and for some reason, OHCS pays you, the state pays you, and for some reason the tenant comes into a windfall of money and they pay you too. You don't get paid double. You have to pay back OHCS for whatever they paid you, or whatever the tenant paid you, you have to pay that back to OHCS. That's all that means. Now, on the OHCS website, there are actually additional required forms that are listed now. A tenant release of information, a tenant attestation form, and a rent rollout template. And I believe the rent rollout template is going to be a landlord template because it basically is an Excel spreadsheet that explains what month, how much they were supposed to pay, how much they did pay, and what the remaining balance is. So there are some additional forms that will be needed from the tenant itself. So aside from the declaration, there are going to be a few more things. Now, again, this whole process is supposed to open up at the beginning of February. So gathering these forms are going to be really important, and gathering them very quickly. Now, OHCS, Oregon Housing Community Services, will be given discretion on how they will choose which landlords get what money. There could be limits on the number of tenants each landlord can receive funds for, and the number of units a landlord must or can own. So they may say that, well, hey, if you own 300 units, we're not going to give you any money. Or that number could be 5,000 units. It's really hard to say. Or they may say, you can't apply for this if you only owe one single unit. There really isn't a lot of definition in the law itself. There just says that there could be some limitations. It doesn't exactly say what they are, but there's a good possibility the money will be doled out in phases, at least, with the first phase being set to $50 million. So there's a possibility they won't just hand out all the funds right away, that instead they will kind of do it in increments, which would be a wise decision because, you know, let's see how it goes at first. All right, so while you really can't evict for non-payment of rent, at least until, you know, July 1st, you can still evict a tenant for violating other rules of the rental agreement. The courts are still open and are hearing cases. So let's say what we call for-cause eviction. So if a tenant is violating the rental agreement, they're, you know, making a big mess or a lot of noise, things like that, you can still send them a for-cause eviction notice and evict them through the courts for that. Also, as mentioned previously, you can terminate a tenancy by selling your home, demolishing it, though there are certain requirements for this. And again, I'm not going to get into the specifics, but usually if you're going to demo a home, there has to be something that you apply for ahead of time, notify the tenant before they move in, those kinds of things. Or renovating it to the point where a tenant can't actually live in the unit during the renovation. You can also negotiate with the tenant to buy them out. That is not prohibited. And have them, if they choose to move out because you've negotiated a buyout with them, they can do that. Again, it's not prohibited. Though I would probably wait until after the landlord compensation funds run out. Because again, you can't ask a tenant to vacate or do a no-cause eviction or terminate them for non-payment while you're applying for funds. And if you're really wanting the tenant to leave because they haven't paid, it's best at least that you try to get some funds from this landlord compensation fund. And so again, you know, we're trying to make this a very short and brief, you know, just the high points on this HB 4401. There are a lot of little things that go and that are involved with it. I mean, you can read the entire language. It gets a little confusing after a while, especially because it includes parts of HB 4213, and it can be a little bit confusing. But those are the big parts of it. And those are, you know, most of the other stuff was already included in 4213, so hopefully you're already familiar with that. And there are so many nuances and details of the bill as it relates to other laws, other counties, things like that. It's impossible to answer or go over everything here. And I strongly urge you again to speak to an attorney for specific questions as it relates to your tenant or your property. If you are managed by us, you know, those are usually things you can talk to us about. And again, if we're confused or we don't know, which generally we have a very good grasp on everything, we'll talk to an attorney for you in a lot of cases. Or if it's specific to your tenant and we want to file for an eviction, we'll hire an attorney to file for that eviction. But this stuff changes so often. As I mentioned, there may be changes coming with Portland. Who knows? who knows if there'll be other extensions. I mean, there are legislators, already talking about what they're going to do now or what they're going to do come July 1st if, there's still a pandemic going on. There's still a lot of people unemployed. So who knows what may change here in the future. If you do have any...
Let's transition to some more questions, Russell.
Okay.
And we do have some questions that have come in. So the first question was, will the assistance be considered taxable income to the landlord?
Yes,
of course.
I would say so. I don't know the specifics of it, but I would have to guess yes.
Second question. So send declarations to all Portland residents. Must be the form, or can I send a balance notice with it, the COVID balance due notice?
So if you're sending any kind of balance due notice, you need to send the declaration form and the notice of their rights. Any kind of balance due notice. Now, again, if you don't, they automatically get the extension without having to fill out anything. So that's, one penalty for you if you don't send it out. But the law basically says you are required to send this form out.
Okay. Are you currently able to sell your home in Portland and evict for that?
Yes. Yes, that has been in effect since July 1st of 2020. So you are allowed. Now, there are restrictions as it comes to trying to sell your home. You have SB 608, and you also have, if you're in Portland, the Portland Relocation Ordinance. So there are some, laws that govern that. And essentially, the only way you can do it is you have to try and sell your home with the tenant still in there. You can't evict them or, for qualifying landlord reasons, terminate their agreement unless you've accepted an offer. So once you've accepted an offer from somebody who intends to live in the house as their primary residence, that's the only time where you can actually then send a termination notice to your tenant. And that termination notice has to be 90 days.
Okay, and then this one is, can the landlord just refund the tenant for paid forgiven rent in lieu of paying it to OHCS?
I suppose you probably could. The language in the HB 4401 basically says that you are required to refund any amounts received from the tenant to OHCS. So, I mean, that's kind of the language of the bill. But, I mean, if a tenant was standing there with the check and you'd say, no, we already got this paid, and the likelihood of it happening, I would assume that you'd be in communication with the tenant already that you're applying for these funds. And as soon as you get them, I assume you'd already let them know that you got it. So it's very unlikely that a tenant's going to pay it anyway. But in the rare event that it happened and they're standing in front of you, you could say, no, it's already paid for. You don't have to pay anything. If they're like, nope, I don't want the state to pay anything for me, I'm going to pay it, here's your money, then you would have to give that money basically over to OHCS.
So regarding the declaration, if you have a roommate situation where one roommate owes back rent, but the other roommate is current, do both tenants need to sign the declaration?
It depends how you have them listed. If they are listed as like single room occupancy with their own rental agreement, then only one declaration is needed. But if they both occupy the one unit and they have one rental agreement, if one of them has paid and the other one hasn't, one of them just has to sign the declaration form, and you can still apply for the amount of money that the one tenant hasn't paid. Because accepting partial payments, HB 4401 has I think it was HB 4401 or maybe it was 4213, but basically they have an addendum in there that says if you're accepting partial payment, it doesn't violate or it doesn't prevent you from terminating or applying for funds, even if you've just accepted a partial payment. I don't know if that really answered the question, but.
And I think the wording, and when I read it, the wording said if one roommate applies or signs the declaration, it's good for the entire rental is part of what
it is good for the entire household. Again, the only way it would be different is if you had a separate rental agreement for each person as like a single room occupancy.
Okay, the next question is, what if a tenant refuses to respond to queries to sign the declaration and refuses all contact with the landlord or the management company?
So there is a possibility, and again, if they're not signing anything, and maybe I'll go back to this chart here, you know, when I was in a separate meeting with another attorney, they had mentioned that it is possible to file for non-payment, like I said, the 10-day notice of non-payment. You could essentially, depending on what city they're in, because in Portland, you probably can't unless Portland rescinds their ordinance. But outside of Portland, and not in Hillsborough, so somewhere outside of Portland and Hillsborough, at least not until February 3rd in Hillsborough, you could send out the 10-day notice. You would have to send the declaration and the notice of rights with it, but you could send the 10-day notice, and if they don't pay and they don't sign the declaration, you could file for eviction, but you can only file for eviction on current month's rent, so not the moratorium balance. And I would probably talk to an attorney about this beforehand, but you could potentially do that if they are not communicating with you, because the moratorium for non-payment balances are through March 31st, and the non-payment balance is from April 1st to December 31st of 2020. So there is a potential that you could file for eviction. Now, if they sign the CDC declaration or the Oregon declaration, then you can't do anything. Or, and again, if they are in the city of Hillsborough or Portland, you can't do anything. But outside of that, there is a possibility.
Now, you might want to mention that if you end up in court, the judge could just turn to the tenant and say, fill out the form and give it to me, and they're done, right? I mean, it's not your example.
Very possible that that will happen, or somebody from, you know, some advocacy, whether it's the Citizens Alliance of Tenants or, you know, some other organization, could be at the courthouse and say, hey, you know, they can't evict you if you just sign this form. I mean, it's very possible that that would happen. So, you know, that's kind of one of these reasons where we're saying, like, we're not going to spend the money or spend the time to try and evict somebody when we know that's a very good possibility of it happening.
So when we send these forms, so do we send the forms, the declaration forms, to all residents with balances so that we can apply for the landlord compensation?
That's what I would do. So the landlord compensation fund is not just your whatever is owed today. It actually includes February rent too. So you have to assume that, you know, if you've got a tenant that isn't paying this month and they've told you, like, hey, I can't afford to pay it anymore, I just lost my job, or I just got sick, or whatever it is, and you assume they're not going to pay February, I would definitely send those declaration forms to those people, because there's a good chance maybe they don't, you know, pay February's rent either. Now, again, it is likely that there's only going to be $50 million set aside for the first go round. I say likely, it is possible that there's only going to be $50 million set aside. You know, with our company, just looking at us in general from April 1st to December 31st, there's nearly $500,000 of past rent that has not been paid. And we're not the largest property management company in Oregon. So, you know, it is a lot of money that even just we have as balances. There is 200 some odd property management companies in Oregon, or at least Portland Metro maybe. So they all have balances. So this money is going to run out pretty quickly. So there's no guarantee you're actually going to get approved, because again, we don't even know what OHCS is going to say is the criteria of what they're looking for to approve these applications.
So Russell, we have another question. This one's a little bit different. How are things in Clark County or in Vancouver? Are they similar? I mean, we've been talking mostly Oregon laws.
Yeah, because House Bill 4401 is just an Oregon law. Now, Washington has their own things going on. So their moratorium is through March 31st of 2021. So you can evict through March 31st, 2021, basically. There are some other, you know, potential places for eviction. but they also have an assistance fund set up through the CARES Act. So very similarly to what OHCS is going to set up here, Washington's already kind of been doing that. And they recently allowed landlords to apply for those funds. Before, tenants had to apply for it. Now they have allowed landlords to apply on behalf of tenants. Now the CARES Act funds, I can't imagine they still have any money left over from that. It's got to be pretty much gone by now. But there was this new federal act that went through that pushed at least $200 million to each state to help with rental assistance. So they may get replenished. They have their own fund. After their moratorium expires, they also have this eviction program or thing that they're doing, where they're basically trying to get landlords and tenants together and create payment plans rather than just be evicted. So essentially, before you can file for an eviction in court after the moratorium expires on March 31st, you have to show that you gave them these additional forms. There's like 2 new forms as part of this process. And you have to show them that you sent form 1 and they didn't respond. And then you sent form 2, and then you get a certificate, and then you can file for eviction in Washington courts. Now, it's not all the counties, but most of the major counties in Washington that are following this thing. So, I don't have any residential properties in Washington right now, so I don't know all of the ins and outs of the law as it relates to Washington and eviction protections and whatnot. But that's the gist of what I do know.
Okay, our next question is, what is the basic difference between the 150 million landlord fund and the 50 million tenant fund?
So the $150 million that are set aside for landlords is essentially through this landlord compensation fund application process that OHCS will be distributing. So that's all going to go through there. Now the state still has $50 million that they can set aside or put to different counties to give directly to tenants. This could be for rent, or it could be for groceries, could be for childcare expenses, could be for the city of Portland, for instance, gave out $500 gift cards to people. So they may give that $50 million, and I haven't heard specifics on what they're doing with that $50 million. But what they did with the CARES Act fund was to give it to each individual county, and each county figured out how they were going to dole it out. Community Action, took care of it for like Washington County and some other counties, whereas Salem had their own or Marion County, I should say, had their own organization that was doling out money. So I don't know the specifics of it yet. I don't think it's actually been announced yet what they're doing with the other $50 million, but that's probably something along the lines of what they'll do again.
Okay, so we have 2 people that asked a very similar question. And I think that the better of the 2 questions is it more advantageous for individual landlords to apply for the rental compensation, or for the property manager to apply on their behalf, who have had the rent deferred? And the other one was, will Bluestone and Hockley apply for the landlord compensation fund, or is it the landlord's responsibility?
Cliff unmuted, so I wasn't sure if he was going to answer something, but go ahead if you got a response on that, Cliff.
Well, I want to hear what you say first, because
Okay.
I know I have a spin on this. I want to make sure we're on the same page.
Yeah, so I would say, generally speaking, that there are, as I mentioned, there's a declaration form, the tenant attestation form, and a release form that the tenant has to sign. These are all forms that you're generally, if you have a property manager, they are going to need to get from that tenant. On top of that, there's additional information that they'll need, like ledgers and stuff like that. So, you could ask your landlord or your property manager for all that information and then apply yourself. And that way, at least you're more comfortable that you're sure it's happening. The one thing I would say is that, property managers, they especially large property management companies, handle a ton of, these tenants, and there are going to be a ton of tenants they're applying for. If you really wanted to make sure that you get that in as soon as possible, then you may want to apply for it yourself. I mean, we have already planned on applying for it for all of our tenants. Like I said, we've already tried to collect all these declaration forms. These new forms that came out are pretty new. I was on the OHCS website the other day, didn't see it, and I see it today. So these are things that we're going to start trying to collect as well. So again, it's personal preference, but I would, and the other part of it is we don't know what the Oregon Housing Community Services application process is even going to consist of. We don't know if they're going to say, hey, property managers can apply for this, or they're going to say, nope, the individual owners can apply for, or have to apply for this. We don't know yet, and we don't know if we're going to be able to submit everything at once or if we have to do it one by one for each tenant. It seems likely we will submit all tenants for one landlord or one owner at a time, but it's really hard to say for sure until we get the real definition of the process from OHCS.
Let me clarify a little bit. The state made it very clear they wanted to protect small landlords versus big landlords. I mean, they've drawn a line, fairly bright line description, and so there will probably be a benefit for us to submit applications in a client's name rather than filing in Bluestone and Hockley's name. Chances are that if we filed in Bluestone and Hockley's name, our clients would probably not get reimbursed because they would see that as part of a bigger group. So we'll assemble all the information, file in the landlord's name and LLC. And again, as Russell pointed out, it all depends on what forms we have to sign off on. Luke?
Okay, so let me see. What if, okay, so going back to attorneys and eviction stuff, right now it's like, what if the tenant who is behind on rent and does not show up at court? They would not have the opportunity to re-sign that form, correct? Or
yeah, if they fail to appear, then generally you get the default judgment. So if you're filing for eviction in court and the tenant does not appear, you generally get a default judgment. Now, does that completely protect you? Not necessarily. There's actually a part in the law that says, a tenant who has, dropped off this form, they could come back and say, no, I dropped that form off to you and, put it in the mail that day or something like that. And so who knows what could happen, but generally speaking, yeah, if they don't show up, you win by default. I mean, who knows how judges are really going to look at it? They may say, try and contact them again and, get them to sign the form or whatever. Who knows? But we're in such a tenant-friendly court situation. I wouldn't put anything past anyone, but typically speaking, you win if they don't show up.
okay, and what if a tenant has vacated the premise and is not cooperating? Is there any possibility of getting past due rents?
So it's a good question that has come up, and we don't know the answer to that. So I believe how the question is basically, if I could reword it a little bit. So if you have a tenant that, let's say, owed money from April 1st to December 31st, they moved out January 1st, they still owe that money. Can you apply for those funds through the landlord compensation fund, even though they're no longer a tenant? It's a good question that'll come up. I have to think the answer is probably no, because the idea is behind the fund is to give you money so you don't evict the tenant. If the tenant no longer lives there, they don't get the protection of not being evicted. So
you have to file in small claims court, right? I mean, basically,
yeah,
to recover, you have to file in small claims court.
After July 1st, or potentially after January, depending on if you're a Portland and stuff like that. So, but I hope that answers the question. You may not be able to file for somebody that has, and we'll see once the application process comes up, but it's definitely a big question that OHCS has been asked, and I haven't seen the answer yet.
Russell, here's a question. It's like the eviction moratorium and the laws are based on tenants there. If a tenant moves out and they have a big balance owing, you can actually take them to court to get a judgment, correct? Or is there still a no judgment at that point? They're no longer a tenant of yours.
The advice that we got from our attorney is that they're still protected by the law and do not report it to their credit and don't file for in small claims court for it. That's the advice that we got from our attorney. Although it's not specifically said, it says tenants, and technically they're no longer your tenant, but I would definitely not do that.
Until June or July or August, right?
Right.
Okay. So it sounds like the declaration form is only for tenants that are behind on their rent, correct?
Yes, correct. So if you have a tenant that is all paid up, then you're not sending them a termination notice. You're not sending them a balance owing. And unless you plan on them not paying rent in February, then you really don't need the declaration form. And, you know, if they're paying, they're good. I mean, that's the gist of it.
We also had a question, where does one get a declaration form?
Now you can get it directly from the language of HB 4401. So if you were to search up Oregon House Bill 4401 or just Google search it, it will bring you to the state website, and you can click on the enrolled PDF, and you can get the text directly from there. I want to say that there's probably a couple other locations that you can get them at as well.
MHCO, Rental Housing Association. I mean, there's a couple of different organizations that publish those forms.
Multifamily Northwest. I want to say there's a couple of places that you can just get it off the internet as well. You can check PHB or Portland Housing Bureau's website and Oregon Housing Community Services website as well.
Let's do 2 more questions, and then let's.
Actually, that was the last question that we had. I did have somebody said, is it possible to get a copy of this presentation? And I believe Abby will be emailing this presentation out in the next couple of days.
That is correct, along with the video link.
Correct. Yes, that is correct. Well, thank you, Russell. That was an extraordinarily well done presentation. Let's give him a hand. There we go. Thumbs up. Way to go, Russell. Thank you so much, Luke and Abby. Thanks for coordinating this. We appreciate that you shared your evening with us. And if you have other questions, please don't hesitate to send them in to us, and we will. Thank you, Asu. If you have any questions, don't hesitate to send them in to us, and we will get them answered for you. And we appreciate you joining us this evening.